You know, there are unintended consequences about everything. And when I got out of law school, they didn't have pattern instructions. And it was I mean, it was a major task to construct the verdict director. I mean, this took hours and hours and hours. You couldn't do it like I'm saying you have to do it now, because you had to know what all the evidence was before you could construct the verdict director. Now with pattern instructions, of course, it's different. The unintended consequence of that is that every lawyer that's out there that graduates from law school thinks he's trained enough to go right in the courtroom and try a case. So as a result, you see many young lawyers in the courtroom who shouldn't be there. Now that's not the bar as a whole. I want you to understand that.
Sure.
But that's an unintended consequence of pattern instructions, in my opinion.
Right.
In those days, one of the main reasons why it was changed, there were so many reversals because of that. It used to be that you had reversals all the time because of evidentiary rulings. Not so much anymore, but you have a lot of them on jury instructions still. But it was a terrible mess when you had those things, because even when you'd have, the fellow's name was Raymond. He was a professional, and he was Raymond on instructions. I don't know whether they still have it out there or not. But in those days, you almost had to hire a professional to draft the verdict director. If you didn't, you almost were sure going to get reversed after trying your case. Now, the bigger law firms didn't have to do that as much, but they all, in a convoluted case, they all used the consultant on particularly on the verdict director. The big law firms today even have a person designated in that firm to be the expert on instructions, even with pattern instructions. I had a general practice for 20 years and had a little bit of everything. The problem with that is that even in those days, plaintiffs' lawyers would try 3 or 4 or 5 cases a year. Defense lawyers were trying cases every week because the insurance companies had designated law firms that would work for them all the time, and they were always trying cases. Just about every week they would be in cases in trial, but not so anymore. By the way, that's one of the problems today. You could get into the courtroom sooner that way in smaller law firms than you can today. The quickest way into the courtroom today is either with the public defender's office or the prosecuting attorney's office. Because if you go with a huge firm, it's going to be 5, 6, 7 years before you actually get to try a case. If you go to the public defender's office, you're going to be trying a case every week. And that becomes something that's purchasable by the law firms after about 3 or 4 or 5 years, if you're good. Because in my opinion, certain people have it and certain people don't. It's not always knowledge. It's the ability to communicate to the jury. It's almost like a teacher. You know, to be a good teacher, you have to have the ability to communicate. And some lawyers have it and some lawyers don't. It's a mystery to me because in this day and age, the cases have become so convoluted with a myriad of issues in them. Those that are tried are usually convoluted cases. Normally, even when I sat on the bench, the normal civil case was like 3, maybe at most 4 days. If you had a wrongful death case where you had individual voir dire with a jury, it could go maybe into the next week. Now you have cases that go 3 and 4 months, you know, and that's beyond my comprehension. The longest one I think I had was like 4 or 5 weeks. But it had a $70 million verdict in it. By the way, I had the largest verdict that that has never been reversed. It was $1 billion.